Today's a long day, so deep breath here. Each one of us is going to give a 1-minute statement of who we are. I'm Judy Simpson. For 20 years, I was the head of the repeat program, and I'm now working for the Reno Vermont as their volunteer coordinator.
I'm Stephanie Walker. I work for Congressman Mark Amday. I was in special election, and we're working for it.
I'm Scott Casper. I'm Dean of the College of Liberal Arts and a professor of history here at UNR.
And a co-author of Input Potential.
Yes.
My name is Mike Haley. I'm the Sheriff of Washington County. Served the Indianapolis for 33 years now.
So in other words, you better behave while it's here. You have the great privilege of being Unit 3, right? And the even greater privilege of going first, so it's out of the way. We have selected question 1 for you today. What are the basic purposes of the 14th Amendment? How are the questions left unresolved at the Philadelphia Convention addressed in the 14th Amendment? And how are due process and equal protection clauses of the 14th Amendment related to the principles of limited government? You may begin.
In 1987, former Justice Thurgood Marshall stated that while the Union survived the Civil War, the Constitution did not. In its place arose a new, more promising basis for justice and equality, the 14th Amendment. The 14th Amendment was intended to address a number of unanswered questions still lingering from the Philadelphia Convention. This included defining national citizenship for the first time.
Furthermore, basic rights were afforded to the newly emancipated slaves through the inclusion of the due process and equal protection clauses. Through such measures, the 14th Amendment placed yet another check on the state and national governments, providing a type of national veto proposed by both James Madison and Alexander Hamilton.
In his notes from the Philadelphia Convention, Madison observed that many in the group thought it wrong to admit in the Constitution the idea that there could be property in men. In an effort to prevent the destruction of a tenuous union in its infancy, the framers compromised on the addition of the 3/5 and fugitive slave clauses. Following the adoption of the 13th Amendment, the status of freed slaves was still questionable. The 14th Amendment addressed this by defining citizenship as all persons born or naturalized in the United States, thus establishing the concept of jus soli. In defining the citizen, John Bingham and other writers of the 14th Amendment attempted to return the nation to the passionate resolve of the Declaration of Independence. For if all men are created equal, then there is no justification for the arbitrary denial of citizenship.
A far more dangerous question left unanswered by the Convention regarded the relationship between state and federal governments. The Constitution attempted to resolve this issue, but a series of crises during the 19th century demonstrated how ill-defined the early federalist system truly was. The Hartford Convention and the Nullification Crisis clearly indicated the overabundant power vested in states in early America, while the decision to go to war with the Confederacy demonstrated the potentially ruinous consequences of this, something that state-specific wording of the 14th Amendment helped to resolve.
The 14th Amendment also addressed the more immediate issues presented to the nation by the Civil War. Section 2 notified the 3/5 clause of the Constitution, while Section 4 provided the debts of the United States shall not be questioned. President Obama's recent fight to raise the debt ceiling was seen as unnecessary to some individuals, as he could possibly use this section of the 14th Amendment to bypass the debt ceiling altogether.
Another intended consequence of the amendment involved the Privileges and Immunities Clause. In response to Barron v. Baltimore, the clause attempted to begin the process of incorporation. However, after this failed in the slaughterhouse cases, the process would not be established until 1925 in Gitlow v. New York, in which the Supreme Court ensured that fundamental rights within the Bill of Rights would limit states with a due process clause. The clause provided a further check on the government's capability to deprive any person of life, liberty, and property, and limited its power over the individual.
This important aspect of the 14th Amendment has been divided into substantive and procedural rights. Procedural due process rights directly limit the government by establishing specific procedures that the government must follow, as in your Miranda rights, while substantive due process rights rely on natural rights philosophy by ensuring that laws have moral backing. Similarly, the Equal Protection Clause found its roots in in the rule of law as expressed in the writings of political philosopher John Locke. It forced the government to treat each individual as equal before the law.
In Gratz v. Bowman, the Equal Protection Clause was used to strike down affirmative action in higher education. However, as the case of Fisher v. University of Texas continues its hearings, that decision and its relationship to the Equal Protection Clause may be struck down. Justice William O. Douglas once said, "No amendment was ever put to wider and more varied use than the 14th. The amendment ensured that the government did not have the capability to overstep the rights of individuals, demonstrating just how much this piece of legislation has come to shape the great American economy." Thank you.
We're now going to ask you some follow-up questions. Stephanie, would you go first, please?
Quickly, how would you distinguish between equality of condition and equality of protection of law?
Equality protection of law.
Equal protection.
I'm sorry, equal protection of law.
Well, equal protection doesn't necessarily mean that everybody needs to be treated fairly. It basically means that if the government is to treat a person differently, it has to have a compelling interest. An example of this is the 2003 case Scudder v. Bovair, in which the University of Michigan Law School stated that it does have a compelling state interest to obtain the diversity of the university.
Yet another example of this is the case of Paradise v. U.S., in which affirmative action within a police department in Alabama was struck down because it did not give individuals the equality of opportunity that you spoke of.
I'm going to ask her to repeat the question to you.
How would you distinguish between equality of condition and equal protection of laws?
Equality of condition is generally described as you have a general condition of being equal. If we look to the case of Brown versus Board of Education, we can generally distinguish this fairly well. In Topeka, the schools that were designated for blacks had similar teacher pay, curriculum, etc. to the white students. So you could say that they had an equality of condition. However, they did not have the same equality under the law, as they were segregated and forced to be essentially separated for ridiculous reasons that did not have a compelling state interest.
Sheriff, would you go next, please?
Absolutely, thank you. How would you explain the doctrine of incorporation?
Well, the doctrine of incorporation involves incorporating the fundamental rights embedded within the Bill of Rights to limit states. Examples of this, there are numerous examples, are cases in which certain specific clauses of these amendments are incorporated to states. So the case of D.C. v. Heller in 2010 incorporated the right to bear arms to the state level.
Another good example of incorporation would be the case of Muir v. Minnesota, which essentially incorporated the right to freedom of the press. Now, the impact that this has had on states, it has forced them to essentially ensure that all of the press within their state is capability of reporting the news in such a way that the government is not involved.
Thank you. Scott?
About the history of questions unresolved in the 14th Amendment, you mentioned the 3/5 clause and the fugitive slave clause. What did the original Constitution say about citizenship, and why was the 14th Amendment necessary to define citizenship?
The 14th Amendment was necessary to define citizenship because of where it falls in history. After the Civil War, we were essentially left with a large group of people who weren't quite yet citizens, but also weren't enslaved. So there was this huge group that we didn't quite know what to do with. However, by allowing the 14th Amendment to define just solely birthright citizenship, we essentially created an easy way for this group of people to become natural citizens of the U.S.
Anyone else?
At the Constitutional Convention, Oliver Ellsworth remarked that states know what's best, so they should decide for the perfection of the Union as a whole, this type of thing. This doctrine was essentially used throughout the rest of the 19th century through the slaughterhouse cases and through Barron v. Baltimore, in which essentially states decided citizenship. That's different from it is now after the 14th Amendment, when states are, you're essentially a resident of the state.
I'm going to ask you a personal opinion question. Several years ago, I had the privilege of meeting Justice Kennedy. And in the course of the conversation, he told us, in his opinion, the 14th Amendment was the most important thing that ever happened in law in the United States. I would love to hear what you think about that statement.
I would absolutely have to agree. The way that the 14th Amendment has affected our judicial system is incredibly immense. If we look to all of the cases since the 14th Amendment, we really see how the Equal Protection Clause and the Due Process Clause specifically have not only expanded our rights, but have expanded the way that we see the Constitution itself.
Also, I'd say that the support for this amendment extends to both sides. Throughout the 1940s, the court multiple times used the process of incorporation for due process, etc. While in the 60s, under the Warren Court, which is far more liberal, they incorporated cases that had to do with criminal protection, such as Malloy and Brown and multiple others.
I'm going to ask you another personal opinion question. This week, the court is looking at gay marriage. Okay? Do you believe that it's possible for that to be done legally without religion entering into it? If we have a separation of church and state?
Absolutely. In the words of former Chief Justice Earl Warren, the right to marry or not to marry lies with the individual and cannot be infringed by the state. Now, this is taken directly from the majority opinion in the case of Loving v. Virginia, which allowed interracial marriage, which at the time was incredibly controversial. And we didn't take religion into consideration in that case, which is why if we look to gay marriage, we can see that we can consider it in the same way.
What's your time again?
We're at 5 minutes and 47 seconds.
We're time.
Sorry.
All right. At this stage, it is our opportunity to tell you how dreadful you were and that we were sorry we ever walked in the room.
We're kidding.
We have 2 new judges in this group who've never seen We the People before. And could they have seen anything better than what we just saw?
Sure. What an impressive job in so many ways. Each of you participated effectively throughout the process. Each of you is an articulate speaker. You knew your material. Within the 4-minute opening statement, you covered all 3 areas of the question. Within the question and answer, you responded to the questions that were asked, and in 1 or 2 cases where it wasn't quite clear you had responded and the question was restated, you came back with a very on-point response. Throughout the entire process, not only did you cite court cases, you explained them and you explained their relevance to the situation at hand. So often, it's quite possible for people just to drop the names of court cases as if we all know what they are. You didn't do that. You really explained how they fit. You didn't just use court cases, you also used examples from American history outside the courts, and you used examples from philosophy like Locke. So you really got at the judicial, the historical, and the philosophical backgrounds that we stress in We the People. So in so many ways, you just did really well.
Mike, in a shorter version of that,
I absolutely can. It's like watching the symphony. In order for a symphony to be really well conducted, each person has to come in at a specific time to emphasize that music or that debate. In this particular instance, each of you complimented each other in strengthening the argument, and I thought it was very well done.
You are all incredibly poised individuals. I thought you handled yourself very well, especially in the case of some of the more challenging questions that sometimes can keep you off guard. You did an excellent job instead of just rambling it to me. You presented historical evidence that supported those, and a great deal of courage.
I agree with everything that's said, but I'm always the one that has the black originals. Casey, you need to find something that is your thing, because we cannot give you a perfect score on participation because you're not participating in the follow-up questions, which is really sad because the other 3 of you were excellent. So the 3 of you have a job to make sure that he has something. You can guess what some of the follow-up questions are going to be, and that he has something to put into it, because I know you want to, okay? We just need to set you up a little bit better. Is that fair, Rich?
Yes.
Okay. So you were fabulous, and I'm so excited that they got to see what we the people really want to see. Okay.
Please rise.
Bye-bye.
That's where it started!
I know her. I remember her from years ago.
Okay, so what do you it's time? Yeah, it's 10:05. Okay, you gotta get
Just like run. So in 3 minutes, we're going to stop. All right, please rise.
Mason, Annie McKay, good to meet you. Nice to meet you, Annie McKay.
Mason, nice to meet you.
Lila, Annie McKay, good to meet you.
Anna, nice to meet
Austin,
you.
Annie McKay, good to meet you, sir.
Lila, nice to meet you. Austin, nice to meet you. All right, please be seated. We've got a big room here, so I'm going to ask everyone to speak aloud and clearly. I'm going to call this Congressional Committee to order. We're supposed to introduce ourselves. My name's Dan Wong. I'm the Chief Prosecutor for the City of Reno. I'm also the Chair of the Law-Related Education Committee for the State Bar of Nevada. And last but not least, I'm on the National Board of Directors for the Center for Civic Education.
Tom Stockard, I'm a District Court Judge, 10th Judicial District.
Hi, everybody. My name is Andy McKay. I'm the Chairman of the Nevada Transportation Authority and lead the People Unit 2 alumnus.
Good morning, I'm Frank Flaherty, I'm an attorney, and I'm also the president of the State Bar of Nevada.
This is Unit 2, how did the framers create the Constitution? And the question we have chosen for you is question number 2. What were the major conflicts in the Philadelphia Convention, and how were they resolved? What arguments can you make for and against giving each state the right to send the same number of members to the Senate? What arguments can you make for and against including the 3/5 clause and the Fugitive Slave Clause in the Constitution? You may begin.
The Philadelphia Convention was an assembly of demigods. Jefferson's statements show that some of the greatest political minds in the world met in 1787 as 55 delegates to amend the Articles of Confederation. However, the result of the convention was the creation of the Constitution of the United States of America. The major conflicts at the convention were distribution of governmental powers between the states and national government, legislative representation, and voter representation.
Under the Articles of Confederation, there was a near non-existent central government, and this is exemplified in Article 2, which states that each state retains sovereignty, freedom, and independence. The fear of a strong central government rooted itself in experience under British rule, and the fear of a loss of state power to that of federal power. This fear also helped establish the Bill of Rights and a checked executive branch under the Constitution.
However, Shays' Rebellion helped this argument of a necessary stronger central government when the national government was unable to help Massachusetts put down a farmer insurrection. As stated in Federalist No. 9 by Alexander Hamilton, a firm union will be of the utmost moment to the peace and liberty of the states as a barrier against domestic faction and insurrection. Ultimately, within the Constitution, those in favor of a strong central government won the debate over state versus federal power, with establishment of such federal powers as centralized military, centralized tax, regulation of interstate commerce, and the Supremacy Clause, establishing the Constitution as the higher law of the country.
The delegates at the convention argued over equal legislative representation in the developing federal government. If representation was based on population, as outlined in James Madison's Virginia Plan, then states with more people would have an unfair amount of influence compared to states with fewer people. However, if representation went according to William Patterson's New Jersey Plan, which was to continue the equal representation under the Articles of Confederation, then smaller population states would have more power because they'd have equal representation for fewer citizens. Additionally, Alexander Hamilton proposed the New York Plan, a system which included a bicameral legislature, an assembly and senate, executive governor with life-term judiciary, nationally appointed state governors, and national veto power over state legislation.
To appease all sides of the argument, the Great Compromise was formed. Its main points being that the House of Representatives is made up of proportional representation, and that the Senate is based on equal representation. The drawback to offering small states equal representation in the Senate is that it creates the possibility of an influential minority. An additional drawback is senators can vote individually, promoting their own personal interests and not necessarily that of the state. Equal representation in the Senate is ultimately acceptable and fair because it balances the House of Representatives, and that states can equally check the executive through approval of appointments and treaties.
The argument over slavery also created much tension at the Philadelphia Convention. The issue was whether or not slaves were considered property or humans. The Southern states wanted to count slaves as people for more representation in the House in Article 1, Section 2. The Northern states felt that the South's desires weren't in conjunction with their views on slavery. Massachusetts delegate Elbridge Gerry pointed out that if slaves were considered property in the South, then his cattle and horses would be represented as well.
The result of this argument was the 3/5 slave clause, as proposed by James Wilson. The fugitive slave clause in Article 4, Section 2 was also established to please the South and impose regulations on escaped slaves. Although compromises were made on the issue of slavery, no definitive decision on the issue would be made until the Civil War era with the creation of the 13th Amendment.
Benjamin Franklin stated at the ratification of the Constitution that there are several parts of this Constitution which I do not at present approve, but I am sure I shall never approve them. I doubt too whether any other convention we can obtain may be able to make a better Constitution. Issues such as slavery and representation brought upon heated debate, yet eventually ended in compromise, where neither sides of the debate were satisfied. Because of compromise, which was the underlying theme of the Philadelphia Convention, the Constitution was formed. Thank you.
All right, thank you. In the creation of our Constitution, our forefathers used a delegate process. They had each state sent delegates to the Philadelphia Convention, and then when it came to ratification, the states sent delegates to a ratification convention within the state. So they used the delegate process. Today, Egypt's people are voting on a referendum on their constitution. Is this an improvement on the process used by our forefathers? Why or why not?
I would say it is not an improvement because, as stated by Aristotle, democracy, when all the people vote and have a say, can be mob rule and mean tyranny of the people in a way. And if the people all have a say and they may not all be educated on governmental issues, that can create problems.
However, on the other hand, the representation, most of the founders at the convention were white property-owning males, and they did not necessarily represent the whole of the people. This was a country of different backgrounds and aspects, and not everyone's voices was accounted for at the convention.
Also, the new Egyptian Constitution
Constitution was formed in less than a 2-day time period in a private convention with no one else present. No representatives were sent to that at all. So it's fitting that the people can vote directly on referendums for it.
What objections did Madison have to the Great Compromise? Do you agree or disagree with this position, and why?
Madison objected to the Great Compromise because he felt like it was just degrading back to the Articles of Confederation, in which the states all have municipal power and tore apart the nation.
And Madison proposed the Virginia Plan at the convention, which he called for proportional representation on a national level. And the Great Compromise had both the establishment of proportional and senators, and he felt that if states had too much power, then the people would ultimately be ignored.
He also felt that one of the problems with the Articles of Confederation was that there was not a strong executive branch to control the nation. Therefore, he wanted a strong executive branch in the new Constitution.
We've been talking about proportional representation. Would you favor or oppose a constitutional amendment that would make representation in the United States Senate proportional? Why or why not?
I would oppose such an amendment, considering that the House of Representatives is already proportional. I think the balance established by the Great Compromise was crucial at the time to having both large and small states ratify the Constitution, and even now to protect the equal say of both in the governmental process.
I would also oppose this. I think this would create too much power in the hands of large states such as California. States such as Wyoming would be underrepresented, and they could not vow for things that they want to pass in legislation.
I would have not been in support of proportional representation in the Senate because, as stated in Federalist 51, states are a double check on the securities of the people, and the states can check the national government as well as support their people in their own jurisdiction.
Do you think compromise is as important today in settling major conflicts as it was in the Philadelphia Convention? Why or why not?
I do think compromise is very important today, especially considering the fiscal cliff that is looming over our heads. I think compromise is needed between President Obama and John Boehner in order to create, so we don't fall off the fiscal cliff and increase taxes.
Additionally, compromise is important for social issues such as same-sex marriage and the Affordable Care Act, anything that relates to people. Right now, different parties want different things, but they should compromise for the benefit of.
And as stated in Brutus I, this country is full of factions, and he wrote this in a time we didn't even have most of the Western United States. So our population is huge, and we have so many different ideas and factions that compromise is essential for our government to function properly.
Proportionality obviously was a big issue for the founders at our Constitution, but there's a factor today that just kind of blows that out of the water, and that is money. So I'm curious, do you think that the founders, if they had that money issue, would also issue some kind of proportionality requirement for the expenditure of money in campaigns? What do you think?
I think they would. Citizens United, which basically said money is your individual right. This has created too much spending in campaigns, as can be seen in the recent election. I think this has kind of corrupted the campaigns in that whoever has the most money has the most say.
I also think that founders created a nation in which people could find equal opportunity. And though, as we stated, the Philadelphia Convention was full of white property-owning males, they wanted to create an environment for equal opportunity for everyone. And the prevalence of money in the governmental process makes that impossible.
And I also think money creates factions that are adverse to the common good, something that James Madison was fearful of. And people are more worried about money than their actual politicians that they're choosing to be represented.
I want to follow up with respect to compromise and frankly the lack thereof. Is there anything that you could see that perhaps that the founders, if they were clairvoyant, could have seen 250 years ahead, what they could do to perhaps ensure that compromise in fact exists, or is it an impossibility in the political process?
Well, I think they tried to provide for the possibility of compromise by creating Article 5 that established the amendment process, so that they knew the constitution and government they were setting up wasn't going to be perfect, and they weren't clairvoyant, so they couldn't see the future. But they made this provision so that the people could make it more perfect as time went on and compromise with their own social issues.
Great job. Very good job. Your 4-minute presentation was excellent, chock full of information, answered the question, but we expect that every 4-minute presentation is going to be good. Where a team really shines, and you did shine, is in the answers to your cross-examination questions. This is Unit 2. I mean, this is a kind of a historical unit. But you know me, I always like to ask, modern day applications. So I asked about Egypt, I asked about money. You handled that without hesitation, with some thought. Obviously, you've been thinking about it, realizing that the constitutional principles that the founders faced aren't necessarily, they don't know about the issues of technology and things today, but they do have principles, and you were able to apply those constitutional principles to the modern day issues. I thought you did a very good job.
And I agree. I think you have an excellent command and understanding of the issues. You were able to use historical examples, whether it was Shays' Rebellion or quotes from Aristotle or Franklin. But you also impressed me with your ability to apply that to modern day applications. The understanding of what's going on in Egypt was very impressive. Citizens United, being able to understand how that creates attention on some of these issues. It's very, very impressive.
I would agree with both judges. The challenge in this unit is being able to apply the Constitution to the questions. It's a challenge. And not only were you able to do it through Dan's question answering that, you're able to point to Article 5, Article 4. You guys went through really almost line by line, for lack of a better term, not literally, but excellent work. I'd give this an AA+ presentation. Good job.
I agree with everything that's been said. The only thing I would add is I especially appreciated the fact that you haven't just memorized the material, you thought about it, you thought about how to apply it to the facts presented to you, and that was very good.
Great job.